Nowhere in these cases, in these petitions, does the state meet that heightened requirement. I'll take my lords to the two relevant paragraphs there, which are also in my written submissions. That is point 3. Point 4, my lords. In response to earlier questions on day 1 and day 2, we discussed that marriage was a bouquet of rights. And what is that bouquet of rights? The table of benefits, my lords. Very briefly, I'll discuss that. It's part of the written submission, so I won't belabor it. But these benefits include gratuity, provident fund, and my lords, dare I say, pension of judges, including Supreme Court judges, are all premised on the understanding of one thing and one thing alone: a spousal relationship created by marriage. We are excluded from all of that. That is my table of benefits at page 35 of the written submissions. That is point 4. Point 5, my lords, that marriage is a matter of conscience under Article 25 of the Constitution of India. Now, my lords have heard arguments on Article 14, 15, 19, 21. They are all extracted in my submissions. I adopt my comrades at the bar who've advanced those arguments. I'm not going to repeat them. They're part of my written submissions. But marriage is also a matter of conscience under Article 25 of the Constitution. And that is my point 5. Finally, my lords, there is a workability table. I will not trouble my lords, but just to say that it is part of the submissions. But the final point I want to say, and I will come back to this also when I deal with the submissions of the statutory body, that is DCPCR, is that our Annexure 6 in my submissions is the only study that is based in India. It has 5,800 respondents, and the study speaks to, 1, the journey post-Johar, how it has impacted LGBTQ people, and 2, how marriage equality will impact LGBTQ people, and that is a substantial portion of the annexure that is part of these written submissions. I couldn't put it in the compilation because at that time I was on a different brief. And of course, my lords knows that the Indian Psychiatric Society has also released a statement commending marriage equality. My lords, may I first take you very briefly to the first submission, my lords. And I will only read very specific paragraphs, and I will not trouble my lords beyond that. That the Indian Parliament is a creature of the Constitution and does not enjoy unfettered sovereignty. May I only take you to one paragraph, my lord? And this is, my lords, as part of my written submission, page 6, para 11. Just page 6, my lord. Just one paragraph of my submissions. My lords have parallel.
Yes.
My lord?
Yes.
I'm just going to read from the middle of this paragraph. This is what your lordships in a 7-judge bench of this honorable court in Delhi Laws Act 1912. My Lord Justice Kaul has the submissions, my lord.
Yes,
Justice Bhatt?
we have it with me.
Thank you, my lord. In the middle of this paragraph, para 12, this is how your lordships and 7 judges in 1951 distinguish India's parliament from that of Britain. My lords say, the Indian Parliament is a creature of the Constitution. Its powers, rights, privileges, and obligations have to be found in the relevant articles of the Constitution. It is not a sovereign body, uncontrolled with unlimited powers. The Constitution of India has conferred on the Indian Parliament powers to make laws in respects of matters specified in appropriate places. The following sentence, and it is constrained in particular by articles found in Part 3 dealing with fundamental rights.
But Dr. Guruswamy,
Yes, my lord.
the point really is that the fact that the canvas which is covered by these petitions also falls within the, or does fall, let me not say also, does fall within the domain of Parliament is undisputed. You cannot dispute the fact that Parliament has legislative power over the canvas which is covered by these petitions, which is entry 5 of the concurrent list.
My lord.
Because just let's see entry 5 of the concurrent list of the Constitution.
Yes, ma'am.
It specifically covers marriage and divorce, infants and minors, adoption,
Yes, ma'am.
wills, intestacy and succession, joint family and partition, all matters in respect to which parties in judicial proceedings were immediately before the commencement of the Constitution subject to their personal law.
My lord.
Right? Therefore, entry 5 also recognizes the position that all matters which prior to the Constitution were a part of the personal law fall now within the domain of Parliament under entry 5 of list 3. Therefore, there's no gainsaying the fact that Parliament does have. So, for us to say that, to accept the submission of the Union would be to transplant the British parliamentary model may not be entirely correct. You are right that the British Parliament, at least before the Human Rights Act,
Yes.
was untrammeled. It was a sovereign. It was an expression of the sovereign will
Yes,
of the people. And therefore, judicial review couldn't certainly extend to striking down a law. Even today, you have the doctrine of incompatibility. But equally, that really begs the question because our parliament has specific jurisdiction in legislative terms by virtue of Article 246, read with entry 5 of List 3,
My lord.
to legislate on this area.
My lord.
Now, the question which we really therefore have to pose is that if this is a power which is conferred specifically on the parliament, does the court then, where does the court really exercise jurisdiction?
Very well.
Which are those interstices which are left open for the court to exercise its powers? Therefore, I don't think we can take it that far to say that, as you have said in your first point, that that to say that this is a matter for Parliament seeks to impose a British parliamentary form. That may be a very, it may not be really a very correct way of stating it.
My lords, may I respond with this, my lords? The argument, my lords, is simply this, that in these areas where there has been legislation, the Special Marriage Act, for instance, in these areas where there has been legislation, the Special Marriage Act, read in conjunction with well-established case law by my lords, both this nature of case, what is the function, what is the width and ambit of Parliament, along with cases like Puttaswamy and Johar, which my lords have made clear that fundamental rights cannot be trammeled. The argument is simply this, that these have to be read conjointly, that we cannot have a situation where the state, when it is remiss, either in discussing something, in creating that positive obligation that my lords have spoken about, both in Puttaswamy and in Johar.
Dr.
That my
Guruswamy,
lords,
just
yes, my
on
lord,
the
Justice
same note, as on the same note, when you're casting a positive obligation on the lawmakers, just go back to the point of time of article. Look at Article 17. It says
Right.
untouchability is forbidden and it's an offense. It
Yes.
presupposes the creation of a law. And the first law that we had was in Civil Rights Act 1955.
My lord.
You're aware of that.
Yes, my lord.
But it was felt to be inadequate. What did the court do? Did the court step in and say this is wrong? According to you, it can. That's one situation. We are in a situation where there is no law, there is no Civil Rights Act. And something as assertive, as positive as 17, if we were to be enforced, how would the court deal with it? We are one step ahead and one step backward also. If it is forbidden and it's an offense, and to be an offense, you need a law.
I
Yeah,
fo-
you understand that. Therefore,
I follow.
horizontal right as well.
Yes.
So there is a concomitant, both things are to go together. That right has to be translated into law. And you can't have a wider right than that. To my mind, there is no right greater than Article 17, which is cast in the most absolute terms. And yet that depended, because you're dealing with an offense, that depended upon the lawmaker, left it to the lawmaker to lay out the conditions in which an offense could be created. Because after all, then you're dealing with someone else's life, liberties, right? So
Yes.
therefore, that legislative vacuum had to be addressed by Parliament through an enactment. So
My
we are almost at that situation. But with not such a wide right. It's a derivative right as of now because of a kind of seamless web which you are trying to expound. That the judgments of the court, starting with decriminalization, a general right of privacy, you're stitching it all and saying that there is an organic growth, which means that we have a right to marry. Therefore, there is need for recognition.
My lords, I follow, and I'm grateful, Justice, but I'm grateful. My lords, if we read Article 17, if I may, with your permission, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. So the text of the Constitution and the drafters made it incumbent upon the legislature to have an enactment, an act of parliament that would in fact make this an implementable criminal offense. It
Even
was not
without that, you could have had it.
my
Even
lords.
without that, you could, even without those, in the absence of that term, it was still possible for Parliament to enact it. But why did they have it? They cast an obligation. Therefore, there are different kinds of rights in the fundamental rights chapter. Now, what you are saying is something which is now recognized as a right necessarily has to be translated into law. That is where I think the Chief Justice's question is very important.
My lords.
Unless we create an obligation, because short of an obligation of that kind, how do we weave out an obligation or a mandate?
My lords, my respect.
Now take Puttaswamy itself. Puttaswamy really arose in the context of Aadhaar. When the Aadhaar challenge was laid before our court,
Yes, my lords.
then Attorney General Mr. Rohatgi argued that there is no right to privacy based on a judgment of the court, our court, which had held that there is no right to privacy. But then there were views saying Khadak Singh and following cases which said that there is a right to privacy. When Puttaswamy came before the court, specifically in the context of informational privacy, which was really the backdrop to Puttaswamy, the concluding part of the judgment says that we would expect that Parliament should come out with a draft bill or a law on privacy. By then, some steps had been taken because the Sri Krishna Committee had been constituted. We took note of what had been done by Parliament, namely the constitution of the Sri Krishna Committee. Obviously, we couldn't issue a mandamus to the legislature. And then we said that this is what we have been assured. So even in the context of privacy, the thing is that these rights the court has contemplated have to be fleshed out by the legislature. There are cases, of course, Vishakha is the classical example where the court has laid down a framework pending the legislature stepping in and creating a law specifically on the safety of women in the workplace. But the test really is this: how far does the court go? Because as your submissions, and this is something which counsel which follow you who should also address us, all your submissions willy-nilly would have some bearing on how we understand the impact of our decision as you want it to be, albeit in the context of the Special Marriage Act, on issues which will relate to personal law. Because there is no doubt about the fact that, adoption, succession, intestacy, these are all matters which are governed by the personal law even today.
My lords, adoption today is
Apart
covered
from-
by the Juvenile Justice Act, my lord. It's
Also by the
civil law.
but you also have the Hindu Succession and Adoptions, the Hindu Adoptions and Maintenance Act.
You do, my lords, but now the legislative mandate for adoption in general is the coverage of the Juvenile Justice Act, which was adopted more recently. It is a civil law and it
That
cuts
was the-
across communities.
It
It cuts
I think
across religious. My lords.
that is true, because for the longest time there was a problem in enacting a law, a general law. But let's not also undermine the Hindu Adoptions and Maintenance Act, because apart from juvenile justice, which you would now refer, that is also one of the laws, and that does lay out certain conditions, and that would govern those who are of that faith.
Yes.
And likewise, there is no other law other than the 2016 Act. There is no other law.
My lords, may I now answer these questions serial-wise, my lords, if I may? First, my Lord Justice Bhatt, respectfully, my lords, my assessment, my lords, and it is far more limited than my lord's assessment. My assessment of Article 17 is that it mandates that the legislature create law to convert Article 17 into an implementable criminal offense. Hence the language in Article 17, the text of the Constitution saying punishable in accordance with law.
Correct.
And similarly, my lords, may I just add this, similarly, 21A, when I was, my lords, and this was perhaps the first big constitutional rights case I argued, the Right to Education Act, Article 21A, and we were before then Chief Justice Kapadia. And one of the points that Justice Kapadia made to me was that even pre-21A, even pre the legislative enactment, the courts had been actively involved in implementing and enforcing this right to education. And he took us through case law. He said, you see, this, 21A and the legislative intent only comes later. My lords have been that North Star, not just for LGBTQ rights. My lords have been that North Star in many facets of fundamental rights, pre the legislature walking the talk. So we don't ask for anything that special today. With respect, we only ask for a workable interpretation, my lords, of the Special Marriage Act. And council after council after council have presented workability tables to my lords, as have I. If it is a question of reading spouse instead of husband or wife, that is one option. If it is a question of expanding the definition and reading in a constitutionally tenable technique, that is an option. If it is a question of taking from 13 of the General Clauses Act, where male includes female, that is an option. We have interpretive options available to this august Constitutional Court. We only ask for a constitutionally tenable interpretation per Puttaswamy, per Johar, pre-Keshavananda, post-Keshavananda, including Keshavananda. That's what we ask. For our basic structure is also intertwined with Keshava and Minerva and what follows after that. That is the purpose of point number 1. We are not that discrete, that distinct, that devoid of basic structure that we will not be read into Minerva, Keshava, and the cases that follow. We are part of we the people, and we are citizens of this country. basic structure also belongs to us. 32 is also our soul. And Parliament cannot be the reason to exclude us from this gamut of our Constitution. Now, my lords, may I just take my lords to page 12 of my submissions? My lords, this is paragraph 23, where the preamble is extracted. And I just wanted to end on this point, which my Lord the Chief Justice had alluded to on day one. Paragraph 24, the right to move this court for enforcement of fundamental rights under 32 gives effect to the phrase to secure to all its citizens. That Parliament is a creature of the Constitution and is bound by it. And within these submissions, my Lord, and I'm not going to belabor this, but if my Lords just turns to page 14 of the submissions, and this is from, as my Lord said, Puttaswamy, which originates from Aadhaar, but makes a very important point of constitutional principle. Whether it's with privacy or whether it's with Aadhaar, but it is a point of constitutional principle that 9 judges of this August Constitutional Court made. And may I just read those 4 lines, my lords, on page 14, paragraph 144. The purpose of elevating certain rights to the stature of guaranteed fundamental rights is to insulate their exercise from the disdain of majorities, whether legislative or popular. The guarantee of constitutional rights does not depend upon their exercise being favorably regarded by majoritarian opinion. And my lords, when Dr. Ambedkar was confronted with exactly this question, whether Indian society was ready for the reform that is the Hindu code, and what about a majority, and how does a majority feel? He said this. He said that it is not a question of numbers. It is not a question of majorities and minorities. It is a question of conscience. I would submit, my lords, that by insulating fundamental rights from the whims and vagaries of majorities and minorities, this constitutional court has created a constitutional principle that Dr. Ambedkar called conscience. My lords have called insulating their exercise from the disdain of majority. From 1951 to Puttaswamy in 2017, from Dr. Ambedkar to Puttaswamy in 2017, the thread of conscience being the test for fundamental rights is a haloed constitutional principle. The chairperson of the drafting committee felt so. My lords have felt so, that there is certain basic rights that are not subject to the whims and vagaries of either a legislature that does not create that positive enactment, which the Supreme Court of the United States in Obergefell said that that constitutional conversation is a continuing one.
Dr. Guruswamy, you are right in asserting that marriage itself is a bouquet of rights. And you identified 3: gratuity, provident fund, pension. Actually, it doesn't stop at that at all. I think the most important social security which is provided to spouses between each other,
Yes, my lord.
apart from, of course, the spousal comfort and consortium, is your entitlement upon the death of a spouse, say
Yes.
in the case of a motor accident or natural death.
Yes.
Now, if we declare, as you say, using the SMA, that, substitute the word spouse for husband and wife, or substitute person for man and woman, for the moment, take it for the granted. That's a simple act of reading up or reading down the statute. But then can we stop at that today? Can we stop at that and say that, look, we'll go so far and no further? What happens, suppose there are two Hindu women who have then married, or there are two Hindu men who have married, and you have one of them dies. Can the court today then say that we will not go into what will happen, suppose, in the case of intestacy? Because there the Hindu Succession Act says, in the event of a Hindu male dying intestate, property will devolve in the following manner. Where there's a clear distinction between what a woman will get, what a man will get. When a woman dies intestate, there's a different line of succession.
Yes.
How does the court today, if we have to go into this, how does the court avoid getting into other issues which are necessarily intrinsically interlinked to what you are arguing? See, so long as you are dealing with broader issues like dignity, the right to family life, that marriage is an essence of human dignity, that people are not trying to denigrate the institution of marriage, but trying to benefit from the institution of marriage. Why should it be confined only to heterosexual couples? That's conceptually the easier terrain for the court to cross. The difficulty is, once you cross the terrain, there's no stopping then. The court necessarily has to...
Just a follow-up question. I think what I would also echo what the Chief Justice is saying.
My lord.
The constitutional or the theoretical underpinnings of your argument and your predecessors is easily comprehensible, and let's say that's it's an achievable target as long as we confine ourselves to that. But if we were to adopt the course that you were asking us to, necessarily one of the important consequences, and I'm not highlighting this as the only, which is what the Chief Justice actually alluded to, is that the provision makes a distinction between personal laws and personal laws. And then which means that a spouse who is not recognized in personal law, but who is treated as a spouse according to our interpretation, will actually lose out in the event of an unforeseen unnatural death. Let's say where one of the spouses have, neither of the spouses have made any testamentary bequest. In such a case, when intestacy follows, the surviving spouse is left with nothing, perhaps even the children, because then the personal laws of succession apply, at least in the case of 4 or 5 communities. According to this very enactment.
Yes. My lords, may I quickly take you to page 35 of my submissions, where we have a series of laws that differently impact same-sex and opposite-sex couples. And the reason why I'm showing my lords this, and this is in tandem with Annexure 1. Page 74 of the submissions to 102, this is an exhaustive list. Now, the reason why I'm showing my lords this is, my Lord Justice Bhatt, in principle, my lord, I already have the principal protection of the courts. I have Puttaswamy and I have Johar.
That's exactly the point.
Yes, but my lords, the problem with being protected in principle is that principle is not enough for the business of life.
We entirely agree with you. There's no doubt about it, Dr. Guruswamy. You're absolutely right. You're spot on. I mean, that's exactly the cause of worry for us also.
Therefore,
see,
my lord, declaration is the first step. The second step would be some illustrative list, like the list we have provided, using workability, which we've also provided. Then the rest will follow, my lords, as it has always followed.
And Dr. Guruswamy, just to play the spoiler here, yes, how many times are we to play the follow-up? That is what worries us.
My lords.
Because if we are not to get into this, just because it suits the certain cases, and that's a thorny issue, aren't we avoiding it?
My lords.
Our job is to look at the workability, not only of what your showing as illustratively.
Yes.
What you have annexed, and some of you have originally annexed, is the correct thing, which is virtually a reenactment of those provisions. Forget reading into or reading up or reading down. We are virtually reenacting, which is, that major, the hard task you're saying we will leave it later. How many more litigations are we going to face? Of course, you can't answer that. But we have to answer it, or many courts will have to answer it. So
My
is
lord,
this our job? Ultimately, we'll come back to the same point.
well,
All these statutes which you have referred to, you have given us 35 examples of the statutes. All these statutes confer social welfare benefits on certain persons, certain categories of persons, right? Upon the wife of a deceased employee, on the husband of a deceased woman employee, so on and so forth, like maternity benefits, provident fund, pension, income tax. So these statutes in that sense are also exclusionary. They define who will get the benefit, right? Now, by accepting your submission, we are going to say that for the purposes of these statutes, these benefits must primarily devolve on the spouse of a same-sex couple, which necessarily means that we are excluding a category of beneficiaries who the statute otherwise contemplates.
my lords, may I respectfully submit, my lords, that I am not asking
So
for that.
essentially what we are doing is, in this process, by conferring benefits on a particular category of persons, the court is necessarily giving a value judgment of who will be excluded from receiving that benefit by interposing somebody who is going to get benefit under that statute.
My lords, may I answer, my lords, with just taking any example from this table? Any example, my lords, but maybe.
Take any example. Take your Provident Fund Act.
Yes, my lords. Or,
Take the Payment of Gratuity Act.
yes, my lords. The Payment of Gratuity Acts, my lords, that's the first in my table, the Payment of Gratuity Act 1972. If my lords please just turns to page 30.
Simple example. If an employee dies without having, say, a single employee dies, not married at all, forget the same sex, the Gratuity Act will define, or the law of succession will define, who will be entitled to those benefits, right?
Yes, my lords, and it only.
Now, by saying that that benefit which is contemplated under the Payment of Gratuity Act should be given to the same-sex spouse of that particular employee, we necessarily exclude employees who would be the beneficiaries who would otherwise be entitled to under the Act.
My lords,
Now, the only point which we are putting to you is this: does this not therefore does this not raise some issue of statutory value judgment?
my lords, may I just say this, my lords? If we just look at the term sex.
These are, because now that we get into.
Follow, my lords.
So, the broader canvas, Puttaswamy, Johar, we've now come a far, long way ahead from there. You need not really labor that.
No, my lords.
Question is, this is now what is the,
Yes.
this is now the worrying,
May I just
not the jurisprudence.
back to the gratuity?
Jurisprudence on 21 is the least bit of a
My lords,
ground.
I said I won't be touching it. My lords, may I take you, my lords, back to the Gratuity Act? This is page.
Dr. Manika Guruswamy,
Please.
see, that's the reason we began by saying that we will, one way or the other, rule on the view you want to be adopted of a status of a marriage and certain whatever consequential benefits arise. Point 4 of Mr. Mukul Rohtgi's argument.
I bow down, my lords.
Beyond that,
This is
when
exactly
you get into the nitty-gritty, and I agree with the Chief Justice, it becomes very complicated exercise. And it is an inclusive methodology and an exclusive methodology both, creating different rights. How can all these scenarios, the complete painting, if I would say, be painted in advance? That's a difficult exercise.
My lords, most of the examples that are given in the submissions really involve only a re-understanding of the marital relationship. That's it, because all of them, the Gratuity Act, the Provident Fund Act, says the benefit goes to the surviving spouse. So here, the technical leap that needs to be made is not much, my lord. It is only about who can be married. The moment we are read into the SMA, then these statutory requirements are satisfied. Because, for instance, the Gratuity Act says can only nominate his oblique her family members as a nominee, and any nomination outside the family is void. The explanation says married, children. These are the nominations. So, my lords, all that we would humbly request, there is just a reading in to who can marry. The moment we are read into the SMA, then these problems dissipate. And that reading into the SMA is a declaration by my lords. Then in
Dr.
all
Guruswamy.
these statutes,
Dr. Guruswamy, may I
my lord,
bring to your attention section 21A, which is very specific, and it is within the SMA. Because if we have to make some provision of reading in under that act, we have to make it consistent with the other provisions. Now, section 21A is a departure. It was brought in 1976 to preserve the application of personal laws in the case of these four categories: Hindus, Buddhists, Sikh, or Jains.
my lord.
Means that you revert to your personal law. Then that brings you back. There is no question of your shying away from this. And like Dr. Singhvi fairly argued about section 27, certain, I think Mr. Rothgi argued about other provisions. The remit of this is very clear, that you will revert to personal law. And in the case, now, as you say, the business of life has to go on an everyday basis. Now we, as arguendo, we declare that man includes woman or whatever, and we say spouse. What happens is, what could happen is, if tomorrow somebody dies due to an unforeseen circumstance like an accident. If it is an accident, there is no intestate there is no testamentary, disposition, and let's say assume there is no will, then necessarily you will revert to the Hindu Marriage Act, Hindu Succession Act, and the order of succession will have to be in accordance with that. The surviving spouse will be deprived. So we will have to make sense of this, and I'm drawing this to your attention because even if we accept your argument about section 4, all this will immediately stand up. We may not go into other statutes, but certainly internal sense of this enactment is necessary.
My lords, there will need to necessarily be internal coherence. There is no way that I would be able to argue out of that. There is my lords will have a declaration, my respectful submission. There would be a declaration. There would be some illustrations, and most civil law would be covered by that declaration. There will be situations like 21A, and those will follow, my lords. And that is the intention of the Special Marriage Act, my lords, that it follows in this way. And we will not be exempt from that. There is no category of citizens that will not have to necessarily follow how the Special Marriage Act devolves in all its parts. It is one law for all, my lords.
Dr. Guruswamy, before the personal law was codified by the Hindu Code Bill in 1956, and then you had various other acts also which were enacted. Marriage, adoption, these were two areas which was, and in fact, intestacy as well, which were all governed by convention, by custom,
Yes.
and by the uncodified Hindu law for that matter.
Yes, my lords.
Therefore, there was the uncodified Hindu personal law, the Mitakshara,
Yes,
or the
my lords.
Dayabhava. Now, what the Hindu code bills did in 1956 was to bring about a codification of this. Now, the Special Marriage Act was, in that sense, an exception. It carved out an exception because it professed to be neutral to religion. The idea was to encourage, or to at least have a legislative framework for intra-religious, inter-religious, inter-caste marriages, so on and so forth. So what it did essentially was to carve out an exception from the general principle that marriage, intestacy, adoption, all matters which fall now within the ambit of entry 5 of list 3 were governed by your personal law prior to the codification by the uncodified Hindu law. Now, what we are therefore, even the argument, I mean, this is something which you need to also reflect on, we need to reflect on. The argument that we confine it only to the Special Marriage Act is therefore this, that you create for same-sex couples a non-religious, right, am I right? A non-religious framework for marriage, and then whatever follows with it. So there's a value judgment in that the court will not give this benefit to those people who still say that, well, I assert my right to stay within the fold of my religion. This is for those who are governed by the secular law, namely the Special Marriage Act. Second, then, even the Special Marriage Act, in the case of these 4 communities, Hindu, Jains, Buddhists, and Sikhs, takes you back. The original act, as it stood, said the moment you apply the Special Marriage Act, you are ousted from your family. The moment there's a severance from your family, you lose all the benefits of being a member of the family. You cease to be a co-partner in the family. This now 21A tells you that, well, you go back. This will not involve a severance from the family.
Yes.
So, which indicates, therefore, that even in respect of a marriage which is governed by the Special Marriage Act, all other incidents of the marriage are governed by your own personal law. And your personal law is intrinsically religious based, whether it is in the case of the Hindu subject to the social reform which was brought about, which was permissible under Article 25, or in the case of Muslims, or in the case of Parsis, Zoroastrians.
It has to follow, my lords.
Quite right. Therefore, there is no denying or getting over the link between even the Special Marriage Act and personal law.
Not at all, my lords. There is no, as litigators, we may be seamstresses of arguments, my lords, between judgments, articles, but there is no getting away from this. I am not trying to say that thus far and no further. I am not trying to say separate but equal. I would never say that. This will be the natural flow. For now, we are suggesting interpretive techniques, a declaration, a broad definition. That is what we are suggesting. In the conversation,
all that can't ever be confined only to the Special Marriage Act. It has to go beyond the Special Marriage Act.
My substituted submission.
Simple point, the income tax officer will say, what am I supposed to do in respect of a gift by a spouse to another spouse?
It will follow, my lords. It will absolutely follow. Therefore, we also had an HMA petition. It will absolutely follow. I will not shy away from that.
Then what your message is, you say this and brace up for more litigation.
My lords.
Because we don't believe Parliament is going to enact anything.
My lords, and I don't believe either, as my lord saw on day 1.
I didn't say we.
No, my lords, we don't believe, my lords, as in
yes,
the lawyers here, my lords, not my lords. No, my lords. I do not suggest that.
Just in the same vein, then are we to speak for the entire, are you to speak for the entire community of the people who are before us? Are you truly representative? There may be diversities. There are diversities.
Certainly, my lords. There are only 19 petitions before my lords.
There may be unheard voices who may want to preserve their way of life, their traditions. I'm not talking of the general population. I'm talking of in the communities that you represent, that they do not want a break from their traditions. And yet, the moment we secularize this and go one step further, we assimilate this and constitutionalize it, as it were. We are in denial of their rights.
My lords, respectfully, those who wish to participate in this new definition of the institution may participate. those who do not wish to participate will not participate. Even today, many opposite sex couples opt for a live-in relationship, even though they have the benefit of marriage.
But they will not participate not because they don't want to participate, but they will not participate for the reason that they do not want to participate at the cost of forsaking their,
Yes, my
their
lord.
connects with their religious communities, right?
That is also a choice. That
They
is
don't want to break those linkages.
will apply to opposite sexes and same manner. And it is a part of years today.
My lords, all our submission on 21A is that we implore this court that the Special Marriage Act, as it is, should apply equally to same-sex and opposite-sex couples. Now, those who choose to opt in, those who choose to opt out, those rights are retained for whatever reason. It may be a matter of faith, it may be a matter of way of life. Those choices are actively exercised constantly by same-sex and opposite-sex couples. But the ability to have that choice is an act of constitutional principle.
Choice that 20 couples.
And 21A gives all couples that choice, opposite sex and hopefully in future same sex. 21A recognizes that choice is being exercised by opposite sex couples on a constant basis. We don't ask for anything more than that, my lords. And I bow down, my Lord Justice Bhatt. I appreciate the point you're making, that within the community as well, there may be those who do not want to exercise this choice. And that is valid principle.
Under inclusion. Under inclusion is a legislative device which is open to the legislature. And we uphold under inclusive classification, saying that Parliament or the state legislature does not have to legislate on everything to legislate on something. That's the principle of under inclusive classifications. But that's very different from judicial review. Judicial review is never by its nature under inclusive.
My lords.
Judicial review is declaratory and applies across the spectrum.
My lords,
To whoever falls within the sweep of the declaration.
Respectfully then say two things, both in alternative. One.
So both in terms, Dr. Guruswamy, both in terms of how we will have to craft such a solution, and on more fundamental philosophical grounds based on the of jurisprudence, on judicial review principles. There is a lot of thinking to be done in this matter.
My lords, your lordships have a burden here. There is no question.
See, all that what you can make out is
My lady.
how far and no further.
My lords, my lady,
That is something which is really engaging us. For you to say that the SMA be brought in line in such a manner that we should read spouse where it's husband and wife and person where it is a man and woman. So far, so good. But there's something more to it.
Certainly. This is a legal and constitutional journey. There is no question, my lady. Like we have thus far made a journey from the days of Suresh Kaushal.
It's being treated by open the meeting.
Expecting the court to take that step, the one step further and stop at that?
No, my lady, our respectful submission is a declaration that expands the definition of marriage, that makes it more inclusive, as has always been the case with the laws of marriage in India, that there has always been an opening up of who can you marry, intercaste, interfaith.
And what after?
My lady, then we will have specific provisions that this would be applied to, and then that is part of the journey. and all the rights and benefits of marriage if a
She muted, no? They're muted. Can't hear, no? Yes.
I can't hear her.
Thanks. It got
Sorry, Ravi, sorry, Sanjay, we lost, we are losing the benefit of having a little chat with you on the dais. So sorry, sincere apologies. We'll talk later. We'll talk across from once we've gotten up at 4 o'clock.
Oh, God.
So sorry.
Well, it's not a phone call.
No, that's okay. We'll continue.
Yes.
Talk later.
Dr. Guruswami, can we suggest one thing?
Yes.
We've placed our perspective on, on certain issues of the matter which are difficult. We'll break here with your submissions. Maybe you can reflect on it and give us a 2 or 3 page note on this. Just sort of put your thoughts together and give it. That will really help us. So we'll go on with now. We'll take up Mr. Saurabh Kripal and then Ms. Grover because they have a little time to,
Yes, ma'am.
to reflect.
Yes,
And
ma'am.
then.
I'm
Thank you,
grateful,
Dr.
my lords.
Kripal.
I'm very grateful for patience.
Thanks for your formulation. Yes, Mr. Kripal.
Option but to address this elephant in the room, which has been raised on workability, Millet. I think that's correct. But Millet, I say 2 or 3 things. First, Millet, Guru Swami alluded about lunch. I was hoping that there is this study in Israel which says that after lunch, judges are more liberal in granting relief because eating food just satisfies me. There's actually a study. I was hoping that will carry on now after lunch. But Millet, in terms of workability and the issue at hand, the question is how far and how much further do we have to go? This is just any other case at the end of the day. It may mean a lot for all of us personally. It may mean a lot for many other people in the community as well. But at the end of the day, my lords are discussing a list which is before my lords. Someone has challenged the provisions of the SMA and the SMA alone and no other act. My lords will therefore decide the constitutionality and mold the relief accordingly. If somebody comes with a petition of the HMA, ABC thing, the doctrine of precedent as earlier evolved, including this case, will then be applied to that case in future and say, well, the necessary implication is that yes, gratuity must also be given to you because we have so held in superior. Or it is not possible because that is the difference between parliamentary functioning and judicial decision making. Parliament has the power and the jurisdiction in one go to have a complete understanding of everything. That does not mean that when there is an infraction of fundamental rights, and I think we must remember that this case is about marriage equality, and we focus constantly on the positive aspect of Article 21, Article 21. There is a very important Article 14 right as well, saying that if heterosexual couples have the right to get married under the SMA, and if you do not include us, non-heterosexuals, within the domain of the SMA, there is a violation of Article 14. What is the consequence of a normal violation of Article 14 or indeed any violation of any article in Part 3? Article 13 has the answer. Article 13 says, my lords will strike down the act. So if my lords holds that non-heterosexual couples have a fundamental right to marry, Article 21, but also have a right not to be discriminated against, because the moment the state recognizes a right in the heterosexual community and says you can have it but you cannot, the obligation normally is to strike down the act. So my lord, under Article 13, my lord will see Article 13.
Yes, of course.
So what is it that we're asking my lords to do? We're asking my lords that normally you would strike down the entire SMA because that is the consequence. If heterosexual marriage is permitted.
Answer this in terms of the previous question.
Yes, well, so I'm saying so what we do.
Under inclusion in Article 14.
Well, the question is whether they will be under inclusion or not. In certain circumstances, under inclusion is permitted. I would say this is one of those cases, sex being part of sexuality, part of Article 15, it is by virtue of the fact that it's a suspect category of classification, they can never be under inclusion on the ground of sexual orientation. That is the argument that has already been made. There may be cases when my lords can underclassify on certain grounds. But the idea of sexual orientation being so innate and already having been held in Navtej Johar, you cannot say today that we will permit underclassification on something as fundamental as a ground mentioned in Article 15. Because why are the grounds mentioned in Article 15 special? One is that they are just a species of the general equality right in Article 14. But Millets, there is something more than to the words used in Article 15.
Striking down the law doesn't benefit you.
Exactly. So Millets,
Right.
so there is a principle of utres magis valeat quam periat. Millets, that is why we are asking for reading in or reading up. These are legislative, these are interpretive devices to save
that-
an act from unconstitutionality.
Mr. Kripa,
Normally, an act like this would be unconstitutional because it is hit by Article 14 of the Constitution. My lord would normally have to strike down the act. Now that amounts to throwing the baby out with the bath water. My lords do not want to do that.
Mr.
The
Kripa,
principle that, please, Melissa.
am I audible or is there?
Yeah, now, yes.
I think there's some lag.
Yes.
So your argument is an extension of what Mr. Rohtigi argued, that firstly, you attribute an exclusion. No matter whether this was intended or not, today you have to attribute this exclusion. Number one, step one is attribute an exclusion. Step two, the exclusion results in invalidation of the enactment.
Yes.
Step three, to the extent of the invalidation, it is rendered void. Now, in this case, there is no question of it's to the extent. There's no question of to the extent of repugnancy being void. It has to go. Then you say, step 4, in order to save it, this is the way out, read in something. Now, aren't we taking too many legislative steps here? Number 2, you're actually bringing in a contemporary intention when the intention was something else at that time when it was enacted.
Yes. If I may address
the second point, that is the first point. The second point is, as a matter of fact, show any analogous case where an underclassification has been invalidated. Overclassifications are typically invalidated. Underclassifications, of course, we have a new matrix now, but underclassifications usually have been upheld.
Yes, please. Well, in the question of the fourth step.
Yes. Yes, please go on. Please.
Yes.
Justice
Yes.
Go ahead.
Yeah. No, Justice Bhatt was asking, but I was just informing Justice Bhatt that
Yes.
the judge was
Yes,
referring.
Kripal.
My lord says that there is a 4-step process. Well, I would submit that this is a very classical 4-step process. There is nothing unusual in what I'm suggesting. Every time the doctrine of reading down is undertaken, there is a similar process that happens, which is there is a finding of invalidity. To that extent, it is or is not, or the entire act is void, is determined, and then an interpretive device is used so as to save something from the vice of unconstitutionality. But the problematic part is the first point my lord made, Justice Bhatt, about we are attributing that there is an inconsistency. Well, yes, because Article 15 and 14 analysis requires the examination of the effects doctrine. What is the impact any law has on the rights of a person is something necessarily which is required to be done when a violation of Article 14 or 15 is to be examined. And it's very clear in this case that by failing to recognize marriage equality and therefore treating and giving certain rights which follow from the SMA, and more than anything else, the recognition by the state of the recognition of your relationship and giving the sanctity of the authority of law to that relationship has a devastating effect on the dignity of an individual as well as the substantive rights of the individual. So well, to say that we are attributing an exclusion, we don't need to. It's writ large. The fact is the operation of the law as it stands today has a disparate, disproportionate impact on opposite sex couples or non-heterosexual couples directly hit by Article 14. So if that happens, I fail to see how we can simultaneously retain an act which gives rights to people who are identically placed like us and but does not give a right to somebody else. For instance, I ask myself, if Parliament were to enact a law that says that people can get married under the SMA only if they have certain property in hand and they do not have other property. So non-property classes, the way voting used to be at one point of time, certain requirements are added, and those additional requirements, a section can be framed positively or negatively. And I'll take my law to one judgment in Romer and Evans in the US Supreme Court. A section can be framed in the form that A and B can get married, but if C and D are necessarily excluded, the section can also be framed and has the same effect as all persons other than C and D can get married. And in fact, Millards, that is the only way to read the Special Marriage Act. Because the way the Special Marriage Act operates today is any two persons can get married as long as they are heterosexual. That is the way the section reads. What is the consequence? The section is also to be read as inevitably no two persons who are not heterosexual can get married. There is a clear discrimination on the ground of sexual orientation in this reading of the section. But that flows logically. There is no violence doing to the act. The section says any two persons, if it is to be read as husband and wife, inevitably it means two heterosexual people can get married. Next consequence, two non-heterosexual people cannot get married. Now the question is, can the law countenance, can the Constitution countenance this form of invidious discrimination against non-heterosexual persons? I would submit, and I'll take my law to the laws to the test in this, because there's a holistic reading of 14, 19, 21. Sometimes there is an overemphasis on 21. But the reason we're also here, and we call it, I repeat, the marriage equality cases, that the moment heterosexual people have a right, you cannot say, well, let's not the good be the perfect or the enemy of the perfect. We can't give you everything, so we'll give you nothing. That cannot happen. In the march of constitutional law and the march of interpretation of the Constitution and our rights, it cannot be said that is an all or nothing approach. It may end up being all, and I hope it does. But it does not mean we do not take the first step. And that is how judicial functioning happens, by precedent. My laws will decide the list at hand, the issue at hand, determine what are the rights at stake, give a finding. If that has an effect or impact on another case, then that will be decided in the other matter. Well, in 1950, the Constitution promised equality of sexes. In 1950. Are we not still coming to court in 2023 saying that there is sex discrimination? Or are we supposed to say, well, everything was given, we will give one judgment in 1950 that henceforth all rights given to women, men are to be given to women as well? That's not how a decision-making process works. That's not how litigation works. We come back on a case-to-case basis, and there's nothing unusual about this. So what we are saying is, if you do not read the word spouse into section 4 of the SMA, then the section is bad. My lords will see section 4 with me.
Different plane.
Yes.
Just I was asking me to commence, resume, but I was. My lords will see section 4.
Yes.
And what is the argument if our declaration is not to be given? The word person will have to be read as a heterosexual person. Notwithstanding anything contained in any other law for the time being in force relating to solemnization of marriages, a marriage between any two heterosexual persons, because everyone else is excluded, heterosexual persons may be solemnized under this act. Can that be countenanced? Because what we are saying is any two persons must include both heterosexual and non-heterosexual persons. And therefore, if you are to restrict by any form of interpretation the two people getting married under this act to heterosexual people alone, then the act is bad. Well, it's some form of a charging section and every other is a machinery provision. This section is the heart of the act. If our marriage is recognized in section 4.
Can we say that the intent by section 4 was to cover same-sex couples?
No, Milad, of course it wasn't.
It wasn't, right?
Milad,
No question about it, because this is 1954 legislation.
Of course it wasn't.
Yeah.
Milad, I asked myself a question. Then the number of times my lords have struck down or read in matters, whenever my lord reads in something in a statute, you don't ever go by what the original intention was. The doctrine of reading in is not some form of finding the original intention and giving effect to that original intention. The doctrine of reading in forms a very different basis of jurisprudence, which is constitutional, to save it from the vice of unconstitutionality. Of course, this was not the intention. But today, the Constitution and today's reading, a statute is governed by the original intention of the parliamentary lawmakers. The Constitution is not. We do not have the doctrine of original intent in our Constitution. We have always seen that it is a living organism. So today, my lords are interpreting certain articles of the Constitution, Part 3 of the Constitution, 14, 19, 21. Today's understanding of this Constitution renders this section void if not read in any other way. We are not at all indulging in an interpretive exercise to determine what lawmakers in 1954 thought. We are indulging in an interpretive exercise to ensure that the rights guaranteed and recognized in 2023 by virtue of this act, my lord's judgment in superior, supposing my lord decides you have a fundamental right to marry. There's also a very fundamental principle in law called ubi ius ibi remedium. There is no point saying you have a right but no remedy. To have a right implies a corresponding remedy.
That begs the question, can we say, for instance, that say the Hindu code bills, when they were introduced in 1956, were far-reaching pieces of legislative and social reform.
Correct.
Because the Hindu code bill, recognized by and by, of course, with the amendments, co-partnership, equal rights for women.
Yes.
In succession, in intestacy, by recognizing that the widow will have an equal share with the children.
But not the right.
But now, can we therefore say, can someone else say who does not belong to the Hindu community, that because this right of equality is recognized only in the Hindu code bill, therefore this law is violative of Article 14 because it does not recognize similar rights in other communities? No.
No, as long as you have an underlying basis for that right.
And the reason I asked you is this, because it's open to the legislature to take up one aspect of a social problem. The problem which it took up in 1956 was the lack of equality within the community of Hindus.
Absolutely.
And created a law providing for equality between men and women to the extent it has been adopted in the Hindu code bill.
Absolutely right.
Therefore, the absence of a broader legislation covering a wider class of persons is not a ground to strike down that legislation.
That is true, Millers, provided that there is no underlying right already in the community. This is a two-step process. My lords will first have to find that there is a fundamental right to marry, which I say my lords will find. Having recognized that there is a fundamental right to marry, Millers, therefore, this is why we will do a simultaneous or an integrated proportionality test. I'll take my lords through that. There's a judgment of my lord, the Chief Justice, on integrated proportionality. How do you test the constitutionality of an act when simultaneously 3 articles, the Golden Triangle, 14, 19, 21, enacted? But coming back to my lord, the Chief Justice's point, it is not open for a member who does not belong to a community and say that they have that right, give it to me as well, unless there is a prior exercise by my lords to say, the horse, aliunde the fact that they have the right of X, you too have that right. Now, my lords, today we are first saying that recognize a fundamental right of non-heterosexual people to marry. Once you recognize that right, if we can convince my lord that there is such a right, that right has a consequence. One is X number have been given a right, some other people are being wrongfully denied that right unconstitutionally. So, hence use this interpretive exercise and grant us that predetermined, pre-existing and pre-found right. So this is not a question of locus to some person who does not have something and a negative argument of Article 14. My lord has always held that there can be no negative Article 14. This is not a case of me saying, give me this right because someone else has it and that is alone. I'm not making that argument. I'm saying you have to read each of these constitutional rights together. I am saying that I have a fundamental right to live with a person of my choice, a right that is recognized in Puttaswamy and Johar. Having found that I have a right of that nature, you cannot leave me remediless, but you need not leave me remediless, because here is another group of people who have that same right. You simply have to do some interpretive exercise to include and give me the same rights. So my Lord Chief Justice's question would be different.
Mr. Kirpal, finding a way to give that right to another set of people within the statutory framework as an SMA, then the aim and object of SMA at that time was, the very premise was,
Yes.
irrespective of faith.
Correct.
The whole thing is based on there being no faith
Absolutely.
in any particular religion and therefore opting for this.
Yes.
So
Even
those-
caste disabilities also.
Both endogamy and exogamy were intended to be excluded. So both same gotra marriage or intercaste marriage are permitted by virtue of the SMA.
Important because this came in before the Hindu Code Bill.
Yes, that's true. That's true. It is
56.
correct.
So keeping that in mind, and that would be what we think would be argued from the other side, would the court be doing violence to the aim and object of the statute?
Of course,
A reading into or reading up, as you
that is my point. We are not asking for my lady to do an interpretive exercise to give meaning to the original intention of the statute, which is what normally a court does in interpreting a statute. Normally you would say, well, that is why you look at parliamentary debates in a statute, because you are bound by what the parliament originally intended.
That's right.
That is always the case. A statute is always interpreted by the intention of its original framers. But in certain instances,
One more example. There's one example you may consider. It's not direct, but again, taking off from your argument that equality existed right from inception. But for the longest time, females were denied a large section of property amongst Hindus, right? Till 2005, when it was universalized. Of course, some states, 3 or 4 states in the south and Maharashtra, they granted these co-partitionary rights to females. And yet we had no qualms enforcing those disabilities, nor even excluding, married people from certain rights towards their father's properties.
correct.
Why? That too is an elephant in the question, in the room today. The why is the court somewhere, these institutions have come up. It's not created by law. They have grown up from society. So those social institutions were recognized, and even as the Chief Justice said, and very aptly, these were custom, these were blessed by custom, enforced by court, and found to be compatible with the Constitution. Therefore, at one go, what you're trying to say is, you may be, getting the right may not be a problem, but the nitty-gritty of it, and you rightly started with that.
Yes, I'm suggesting
getting the right may be not such a insurmountable issue. Getting to the other part, making it workable. These are all the, not one, many, a herd of elephants in the room, which you will have to address.
Yes, Milind. So coming back to this question, Milind, the nitty-gritty versus the recognition of the right. So Milind, first thing I say is, there is a constitutional obligation on this court. Having found a right, you cannot say that because of legislative draftsmanship, your right is effaced. Because that will necessarily be the argument that the legislature has created so many hurdles in the free exercise of a fundamental right that your fundamental right itself ceases to have meaning because it cannot be enforced by court. Because that is the argument of the other side. That look, you may have a right to marry, but we can't give it to you because we have drafted our laws in a way that your right to exercise that is impossible. That is what the argument would then be, that the Constitution normally by virtue of Article 13 would trump a statute. But if you frame a statute sufficiently complicatedly, you can trump a fundamental right. That is the argument, effectively. Because what is the consequence of the argument of the other side? That because it's unworkable, therefore do not give them a fundamental right. That is the inevitable argument, Millets. And I dare say that there is no greater constitutional anathema than that argument. Because tomorrow they will frame all kinds of laws, parliament, whichever parliament may come, and say we'll start defeating your fundamental rights because we'll make them unworkable. A workability argument, Millets, is no part of an Article 13 analysis. My lords will simply say, is there a constitutional right and has that right been violated? And if it has been violated, there is an all or nothing approach. Either strike it down or uphold it by reading up, reading in, or any other interpretive exercise. But to say you have a right, but because it is unworkable, we will do nothing about that right, allow that injustice after having found the right, and suppose the parliament does not intervene. I give the example of Nepal, because the tactic there was also tried, Millets. In Sunil Pant, a decision comes 6 years ago by the Supreme Court of Nepal that we direct you to frame laws in accordance with the constitution and find a right. Nothing happens. So are we then going to live in a lawless society? Is that the argument from the other side, that we expect you to live in a lawless society, that the Supreme Court of India, having found a constitutional right which inheres in you, sorry, there's nothing we can do about it. We leave you to the mercy of Parliament, which may or may not act, and has shown in the last 75 years in terms of LGBT rights that it will not act. Well, that is a complete anathema to the rule of law, but also to the constitutional scheme. It cannot be argued. This argument cannot be countenanced.
Mr. Grewal, thank you. We'll call upon Ms. Brinda Grover now. Anything, sir, you want to supplement?
Just one thing I wanted to give actually on the issue of the composite test.
Yes.
And I'll just give, I don't think I need to do very much. I want Ms. Grover to have her time. There's what I have done is given a copy of the relevant extracts of judgments in my note. I have not actually given my submissions, but my lord has a supplementary note. I believe it is.
Yes, it's here.
Yes.
Yes, in the compilation. And it's just 1 or 2 paragraphs I'll show from that. Because while we do this analysis, constitutional analysis of 14, 19, 21, and this, of course, I'm beseeching as one composite test, the effect of the violation of any one fundamental right has a different consequence in law in terms of the relief my lords will give. So Article 21 will give a positive relief, and Article 14 typically will give a negative relief of striking down. But in certain instances, if that yields a constitutional chaos, my lords will also read it up, is what I'm going to argue, what I've argued. That's the effect of Article 14 analysis. My lords will just see this Akshay Patel, the proportionality analysis, and I'll just para 27, the beginning. Adopting proportionality analysis not only provided a formal structure through abstract rights litigation can be analyzed, but it is also, when applied properly, has the potential to improve the quality of judicial reasoning while protecting individual rights, as noted in Aadhaar. My lords will leave this, come to paragraph 30, where it says, this is when used. I'll just in Puttaswamy, turning the page, on the top of the page. Hence, the court can adopt, top of page 2 of my note. Hence, the court can adopt integrated proportionality analysis where the limitation on each of the rights is common and affects them in a similar way. So I would submit that in the present case, that is very clear. Both my right to expression under 19(1)(a), my right to equality under 14 and 15, and 21 dignity rights are affected in the same way. Namely, I'm not allowed to get married. And so there is a 4-pronged test which is given in paragraph 31, Romans 1, 2, 3, and 4. Is the measure in furtherance of a legitimate aim? I would submit the only legitimate aim is a legitimate purpose that I think has been addressed substantially. The only legitimate purpose that can be pleaded in the counter, and 2 have been pleaded. One is the importance of marriage as a social institution, which is a legitimate purpose. But the second purpose which has been given, which is that it is contrary to the will of the majority, is not a legitimate state purpose because it is contrary to Johar. Constitutional morality is the only legitimate purpose. So at that point, so there is some legitimate purpose. So clause 1 is satisfied. 2, is the measure suitable for achieving such an aim? Namely, is prohibition of non-heterosexual marriage suitable for achieving the aim of strengthening marriage? That was the question that my lord will have to pose. I would submit the answer is no, because how is it suitable? If you want to strengthen something, you add to it, you don't detract from it. I'm just going to speed through. Point 3, is the measure necessary for achieving the aim? Answer, clearly not. You do not, is it necessary, is excluding non-heterosexuals from the idea of marriage necessary to strengthen the idea of marriage? Answer, no. What you have to do is ban divorce. We talk of personal law. After all, Hindu law recognizes that a marriage is sacrament, insoluble, indissoluble. Yet divorce is permitted. So if you really want to strengthen the act of the institution of marriage, then you have to stop divorce. More importantly, Millets, if non-heterosexuals are excluded from getting married, what happens typically in our society? Lavender marriages. It is very common for a gay man to marry a woman, or a lesbian to be trapped in an unhappy relationship with a man. 2 lives are ruined. Is that how we are strengthening the institution of marriage? Because that would be permitted as per the union's argument. As long as you are of the opposite biological sex, you can get married, and that will somehow promote the idea of marriage. And I would say there's nothing more detrimental to the idea of marriage than a gay man marrying and cheating maybe a woman whose sexuality is not revealed to it's rather surreptitious. Point 4, is the measure adequately balanced with the right of the individual? Well, this is really a question of proportionality and balancing analysis. It's rather Kantian in its idea as to the effect it has on one person. I was reminded of that trolley problem we all studied in university, saying that it may be that one person's right is sufficient to trump the entire community's rights. And here, please analyze the impact on me for not being able to get married vis-a-vis what? How is the right of any heterosexual person to get married getting affected by my getting married? That I'll just leave. And I had my note, has it? I'll say nothing more. The economic impact of failing to recognize marriage. Has it? There's one study which shows, and it's there in my note, on page 10 of my note, it's almost 1.7% of the GDP of this country is affected by failing to recognize LGBT relationships and giving equality to LGBT relationships. There is a lower lessening of productivity. And most importantly, Millets, in the matter that I'm appearing in, a large number of people, at least 5 of these petitioners plus more, have indulged in what is called the gay brain drain. If you do not allow marriage in this country and people want to get married, have children, have other rights, the best minds, I'm not saying non-heterosexuals are the best minds, but they're not bad minds either. If they all leave this country to secure freedom outside this country, I do not see how public interest is furthered. That will result.
Thank you, Mr. Kumar.
Thank you, Mr. Kumar.
Grover?
Thank you.
Please, my lords. My lords, I represent.
Yes.
My lords, I represent petitioners who are a little different from the nature of petitioners who have been heard till now. Some, Mr. Ramachandran and Mr. Vishwanathan, were perhaps of similar context and background. My petitioners can be broadly classified into 2 groups. Petitioner 1 to petitioner 4 are queer, feminist, and trans activists. They have, for the last few decades, been part of providing shelter, emergency helpline, etc. And they form what is called the National Network of Lesbian, Bisexual, Intersex Women and Trans Persons. Petitioners number 5 to 10, who have been anonymized even in this petition because of the precarity of their lives, they are 3 couples in relationships involving a trans person and a cis heterosexual woman. And therefore, my lords, I would urge that while for shorthand we are using the term same-sex marriage, perhaps as was said by Mr. Kripal, these are marriage equality petitions before my lords. And I would say address that my particular petition is about marriage and relational equality. And I will come to that a little later. My lords, why this need for marriage? Much has been said about this. If I would just speak about drawing upon the experiences and the lived realities of these petitioners. On 1st April 23, a closed-door panel hearing was held in this city by PUCL and the National Network, where 21
persons of different sexual orientation and gender identity deposed, centering, the focus was on familial violence on persons of different sexual orientation and gender identity. Why I need to focus on this is that there seems to be an assumption that the families will necessarily be supportive. They are fortunate, and it's good that some are, but many may not be. And these come from very marginalized contexts in terms of class, caste, religion, and the primary source of violence, hostility, interference, is the natal family. And therefore, why does marriage become such an important legal shield, a legal protection which goes to the heart of Article 21 also? My lords, I will point to two excerpts. My report of that public panel hearing is in volume 5.
Actually,
Of
can you just,
compilation two.
Grover, can you sort of summarize your points so that we can take your submissions down and
My lords, I actually have put them in just past.
formulate the 3 or 4 key points so that we can take them down in bullet.
I will just do that. I've actually also put them in a 4-page note so that
You've submitted a supplementary note, right?
yes, a supplementary note just this afternoon for ease of,
Another one.
for
Besides
convenience
one
of the court as to what is it that I will be addressing.
Short submission.
Please, my lords.
Yes, short submission.
This afternoon, my lords.
14
1
page, we have got it.
Yes, this is a shorter, the 14-page one. The 14-page one.
14 page.
Please, my lords, it's the same. Where the prayers and the distinct issues. I'm not taking my lords through the issues that are already covered.
We have it.
With,
We have this.
please, my lords, I'm grateful. My lords, the distinct issues and my specific prayers relate to one is a declaratory relief vis-a-vis this.
Port 1 का इंटरनेट नहीं चालू है. Brother Call, do you have this?
It was
14 page.
Yes, I have it. The 14 page, na?
Yes.
14 page.
grateful, my lords. Justice Call also has it.
1:15.
Justice Bhatt also has it.
इसमें डाला है? नहीं ना? Okay, अच्छा ठीक है, problem. इसमें है, ये है, वो अच्छा. Yes.
Please, my lords. My lords, my prayers are.
Para 11.
My prayers are in the last page 13, para 11, which would encapsulate what my main submissions would be. One would be a declaratory relief vis-a-vis the Special Marriage Act to save it from unconstitutionality, and many arguments to that have been addressed. The second, and on the notice.
So A and B have been fairly.
Please, I'm not going into that at all, my lords. On the notice, domicile.
What's happened is that the internet is not working.
Yes.
My lords, the Chief Justice has it?
Yes.
Please, my lords. My lords, on the notice domicile objection regime, again, I'm not going into it, although I am saying that it is not only for, we are seeking a striking down of sections 5 to section 10. I am relying upon, I may not have a chance to address on that, but the intersectionality and particularly the patterns of marginalization and discrimination that these persons find themselves. And there is already judicial evidence to the effect of how persons who are from particularly marginalized groups continue to approach the court even to get married under the Special Marriage Act. I will then come, my lords, to page 2 of my.
Is anybody before this court for seeking the relief at D? Your D.
I beg your pardon.
Prayer at D.
Prayer D. Please, my lords.
Anybody
Please.
for us seeking this relief specifically?
I am not sure.
Because the way it's been worded, we haven't come across.
I don't think so. I don't think so. That's why I would be grateful. It is a distinct issue. Your ladyship is right. It is a distinct issue. But I would today be emphasizing on E and F. My written submissions deal with D. Today I will emphasize on E and F, which are again
instead of
D. My today's E. I see. Please. Thank you. My lords, my specific prayers, before I come to that, I only want to draw the attention of this court to Section 3 of the Transgender Act. The transgender issue was dealt with by Ms. Kothari. In Section 3 of the Transgender Act mandates pursuant to NALSA a prohibition against discrimination against all transgender persons, and actually then specifies in terms of health, employment, rental accommodation, educational institution, etc. My lords, the argument, and if this is read with Section 20, which says that this law is in addition to, the argument that I am submitting here is that the Transgender Act necessitates that the Special Marriage Act provides recognition to marriage between trans persons and whoever is the other partner in which the marriage is taking place. Because without that, there would be an inconsistency in the reading of Section 3 and the Special Marriage Act. And perhaps the harmonious reading would require to read both in order to ensure that the rights guaranteed by Section 3 don't remain illusory, as well as to provide consistency between the two. Section 3 actually necessitates the recognition of marriage under the Special Marriage Act. My lord, the next aspect, I will not go into indirect discrimination, intersectionality, all that is taken from the judgments of this court and is before the court. I will go immediately to what is a distinct aspect. One, we are saying that given the nature of natal violence, and this natal violence is severe, if I can just read that, if I can just take my lords to Volume 5, Compilation 2, PDF page 125. Volume 5, Compilation 2, my lords. It has only one document. Actually, that is the report of that hearing where 31 persons testified and stated what was the nature of violence they had faced from the natal families, coming from small towns and rural areas.
Official report.
Volume 5.
Yes.
Volume, Compilation 2, my lords, Volume 5.
Running into 227 pages.
I'm grateful.
Family violence in life.
Please, my lord.
Years. Which part are you?
I'm at page 124, PDF page 125. Internal page would be 124, PDF page 124, 125. It's
Ongoing
titled Ongoing Negotiations.
negotiation.
Please, Your Ladyship. Hair and clothes are markers of identity, gender expression, and one of the first markers of identifying somebody as belonging, who may determine their gender identity differently. In fact, the act of cutting the hair or keeping the hair long invites consequences which can range from house arrest, no schooling, post-marriage at 14. These are all testimonies before my lords, as well as corrective rape. I am reading only one testimony here. Every time I go home, I need to cut my hair, dress differently, misgender myself, and it is an intensely difficult experience. I cannot express in words how intense it can be, even though it does not look like what I'm experiencing is violence, or it is not as intense. It is there when I have to keep pretending with them. There is this insistence that I need to survive, for which I need education, so I have to keep doing it. My lords, the reason why I'm drawing my lord's attention to this is, what is that unit to which persons who are facing the ire, violence, and from the family, from the natal family, where do they go? What social formations do they make? One is under the Special Marriage Act, if we succeed in persuading this court to allow them to be married, and that marriage provides the legal protection and the legal shield, which the natal family did not. That would, if my lords would now come to my prayer E, which may be distinct and different from the other prayers that are before this court. Page 11. Page 13, my lords would see prayer.
I'm sorry, Ms. Grover, there's a lot of confusion in the nature of volumes.
I'm so sorry, my lords.
There's one volume 4 by Vrinda Grover and Shivam Singh. Then there is another volume 5. There is another volume 4.
The report was only in volume 5, and I only wanted to read one excerpt. I will not be referring to volume 5 again.
Now, volume 5.
That is only the report, my lords.
See, with all due respect to the council who have been coordinating, these volumes and additional volumes need to be numbered, or in some way there has to be a rational rechristening. It is difficult to manage, and as we go along it will be worse. I'm still not able to locate this. There are 2 or 3 volume 4s and volume 5s.
Feel corrected, my lords. I apologize. My lords, we have also been giving them last minute, so it's not fair to put the blame on her.
All right.
Yes, all right.
My lords,
What are the points?
the crux that I'm referring to, my lords, we are saying that one is, as has been said by others, to provide recognition through a declaratory relief under the Special Marriage Act and the striking down of sections 5 to section 10 of SMA. My lords, the other prayer that we are seeking is that, as my lords knows, both family and marriage, there are, based on experiences and analysis, there can be a feminist jurisprudence and a feminist critique of family. There is a critique of the family that it may perpetuate caste purity and patriarchal control. So there are persons who may...
Yes, please go on.
Yes.
I'm just waiting for the Chief Justice.
Yes.
My lords, there are persons who are of different sexual orientation and gender identity who, because of the hostility of natal family, actually have intimacies which are non-conjugal in nature, which may be non-marital. They are non-procreative desires, but they are intimacies, and that is the only support, the only social enclave of comfort, care, help that they find. My lords, for instance, during COVID, a study that was done on trans persons found that when trans persons, due to lockdown and the nature of the disease, had to return to their natal families and their homes, over there, they faced violence, they faced prohibited conversion therapy, and that was actually an illustration of what would happen if other social formations of care and support did not exist. This is what my lords has described as atypical family. This form of chosen family is recognized in our law. My lords, for instance, adoption. Adoption is a form of chosen family. Today, we recognize families and we conceptualize family as by blood, marriage, or adoption. But that is a form of chosen family. My lords has also, if my lords would just see, I have listed here the Mental Health Care Act. My lords would just have section 5(1)(c) of the Mental Health Care Act. There is increasing legislative and judicial recognition of persons who may not necessarily be conjoined through marriage or conjugal intimacies. My lords,
Yes.
I'm referring to section 5(1)(c) of the Mental Health Act, read with section 14. In relation to advance directive, every person who is not a minor shall have a right to make an advance directive in writing, specifying any or all of the following. C, the individual or individuals in order of precedence he wants to appoint as his nominated representatives as provided under Section 14. Section 14 talks about appointment and revocation of nominated representative. And my lords would see that what the legislative intent here is that here is a vulnerable person who may not get necessarily the support and whose personal autonomy may not be respected by natal family members or persons by blood or marriage. And therefore, in such a circumstance, the legislature is giving primacy over and above blood and marriage to a nominated representative. My lords, in my particular case, petitioner number 1, Rituparna Bora, is a queer person, and both her parents have passed away. Her father was supportive. She's now left with a family that does not understand, respect, or support her sexual orientation. She also has a debilitating disease. She needs persons who will care for her. She needs persons who will take decisions on her behalf. She needs persons who will understand what is in her best interest. If she is left to the mercy of the natal family, because there is an assumption that they would hold my best interest at heart, because of my sexual orientation, gender identity, the natal family may not be the primary carer for me. Therefore, in such circumstances, intimacies are formed, which may be conjugal in nature, which may not be conjugal in nature. But these are chosen families. My lords, has para 26 was read earlier, I will not repeat it, about atypical families. My lords, one more example, when one looks at international law, the Yogyakarta principles were read out. I would like to read another part of Yogyakarta principles, Principle 24, Part B, which actually talks of diverse forms of marriage and says families not formed by marriage or descent. And therefore, this recognition and acknowledgement that there is what my lords has described as an atypical family, and which can also be referred to as a chosen family, that chosen family need not be by blood, marriage, or adoption. My lords, I'll just read out the relevant part of Principle 24. Ensure that laws and policies recognize the diversity of family forms, including those not defined by descent or marriage, and take all necessary legislative, administrative, and other measures to ensure that no family may be subjected to discrimination on the basis of sexual orientation or gender identity of any of its members, including with regard to family-related social welfare and other public benefits, etc. So in the imagination today, both in terms of marriage and in terms of family, my lords, I would say that what we are canvassing before this court is a different imagination, a new imagination of marriage and of relationships and of family. Imagination which actually places at the foundation love, care, respect, which may or may not come from the natal family because of my sexual orientation and gender identity. And there is data and evidence to that effect. My lords would then say, judicial recognition has been given to Hijra Gharanas, which are well-established social formations in South Asia. In terms of legal heirs to succession of property, high courts have recognized members of the Hijra Gharana. My lords, why do I need this chosen family, apart from the description of violence that I've placed before the court? What do rules and laws require? I have to visit a person who I actually share an intimacy with in jail. Petitioner number 7 before my lords today actually is facing a case of theft and abduction imposed by parents of petitioner number 8. It's common practice. Who will come forward when a person of this sexual orientation has been falsely implicated? Who will come forward to visit me in jail, stand for bail, etc.? Bail, okay, there can be a wider consideration if you have control over the person. Again, to take rites to be performed at the time of death. or how I am. There have been very traumatic testimonies, how misgendering takes place at the time of death, how I am dressed for my last passage. All these, who would respect? Not the family that abandoned me and that inflicted the violence on me. For all those reasons, the chosen family, even beyond non-conjugal intimacies, today is seeking recognition, because without that, they have no support structures through which they can live. I will just end, my lord, because I know I am almost out of time. One prayer refers specifically to nomination, that I may be allowed to nominate as next of kin a person of the chosen family. My last submission, my lords, would be that where, as has already been said by Mr. Ramachandran, that what is the protocol to be adopted? There is one protocol available in Shakti Vaini, but as it fell from my lords, the Chief Justice, that these protocols should not trample upon the agency of the persons concerned to whom protection is being given. And therefore, I would urge that in nature of Garima Greh for trans persons, similarly, safe houses, shelter homes, where the NGOs and the queer persons themselves are involved in running those spaces, which is already happening under the ministry, as well as reiterate Arnesh Kumar specifically for these persons, because they stand at a greater risk. I have, and there is an order, if I may refer to, of the Madras High Court, the S. Sushma order, which is a continuing mandamus in which multiple such directions have been passed. There is a glossary that is available, my lords, at in volume 5, PDF number 205 and 216. This glossary has been prepared by members of the community themselves, and therefore may be of some assistance in how they are to be referred to and what is the preferred way of addressing.
Thank you so much.
Please, my lords.
Now, we've heard 11 counsel on this side. We had planned to complete all submissions today. At the most, we can give about, say, 45 minutes tomorrow morning for everybody else to wrap up. So I would think that we can give 10 minutes to Ms. Karuna Nandi, 10 minutes to Arundhati Kajju. Then we would request all of you to ration time. Jaideep Gupta is for the interveners, Mr. Tulsi Raj is for the interveners. Then you have, after Arundhati, you have Amritananda Chakravarti, Raghav Avasthi, Shivam Singh, and Manu Shinar. We'll start tomorrow morning at 11 sharp because we take about 20 minutes for the mentioning and then 5 minutes to regroup.
Yes, my lord.
I'll also talk to Justice Kaul and Justice Bhatt. Both of them are still recovering. Perhaps they can, I'll have a word with them, whatever is convenient and medically advised. But tomorrow by, Mr. Solicitor, by 11.
We'll stick to our time, my lord.
45 we will request you to, yes.
We'll stick to the time.
And we request everybody else to just give us a page of bullet points, just a page of bullet points so that, you know, if you can put it together and that will just make it easier for us to know what the formulation is. Because now we've seen the whole gamut of material. If you just get your formulations on one page in bullet points, I think that will be good enough. Brother Bhatt, Brother Kaul, both of you, do you think that's all right if they give us just on a page the formulations on bullet points?
Yes, he does.
So that will just make it precise and sharpened, you know.
We'll pare this down further, my lord.
So
Just before we break,
sorry, Brother Bhatt.
Can I put one question? You could just answer it by a note even. Ms. Grover.
Please, my lords. Please, my lords.
And there's very interesting, this recognition of the Hijra Gharanas.
Please, my lords.
Is there any documented material about forms of marriage between transsexual persons?
Please, my lords. There is. I will place that on record. I will place that on record. I'm grateful.
Thank you very much, Ms. Grover.
Please, my lords.
Thank you.
Thank you.
Thank you, brothers. Thank you.